suggesting that she take it, the class we're taking.
With trial?
Yes.
We suggest
Your class, of course.
yeah, my professor.
I'm taking the Judge Cornetta's class, the trial court practice and procedure.
That's a good one.
It's a wonderful class, and it ties in so nicely with this class.
Does it? Good.
It does.
Anything with Judge Agnes or Judge Cornetta, you can't go wrong with.
Bless you.
I have both of them. Do you? Right? And I'm not wrong about that, am I?
No.
Yeah, they're both brilliant, you know.
It's just such an asset for the school to have a
No, they're both great guys. And I haven't had them, but the feedback on Judge Sullivan is very good as well.
He's a wonderful man.
Justice Trainer too, by the way. I don't mean to leave out some of the others. They're actually, we've got, I think that's the four of them, right? Is that all of them? No, but they're all very, very good. Real gentlemen, and very nice to talk to, very nice to work with. They're great. They're really...
There's the case prep class with
Oh, Judge Edgerton as well.
he's awesome.
I don't mean to leave.
I recommend him.
They're all very, very good. Both individuals, teachers. Great. We're very, very fortunate with the judges that we have, and the commitment to teaching that they put into it as well. They're all both. They're all scholars and great teachers. So. If you see, if you're undecided at some point, trying to figure out which one should I take, any of those folks you could enjoy. Judge Sullivan's is obviously a landlord lieutenant, so you'd have to have some interest in that specific area. But he's a super guy. They're all really first-rate individuals, not just teachers. They really are great guys. Very lucky.
Okay, turn off the tape.
No. We could, but I think they all know how highly I respect them anyway. They're really, very, very fortunate. I mean that. It's not just PR. They're nice. They're nice people too. And frankly, that's not always the case. Not just with judges, but even with law professors and lawyers. But we won't go there tonight, Melanie. But they really are first rate in every way. So tonight we are rapidly closing out our book, and we're in section 14. And we're going to talk about some pretty traditional equitable remedies, resulting trust, constructive trust, declaratory judgments, important concepts as they've been for hundreds of years. And we're also going to look at, and probably more Thursday than tonight, this other issue with this other body of law that we really don't become exposed to much, but the notion of ecclesiastical courts. The idea that there are some types of cases that are not going to be resolved through the civil court process. I've actually had people ask me in the past, well, how do you get an annulment in a church annulment is what they mean. How do you do this or that with respect to matters that are not going to be found in our civil procedure books and the like, but we're going to have to try to find out information about courts and court processes that are either within the church or the temple and the like, where we're going to be in a pretty unknown area, in an area that's not nearly as clear, frankly, or as open as our civil courts as well. But from time to time these matters come up, and especially more recently they've come up with respect to the issue of closing some of these churches, with respect to even the church sexual abuse cases. One of the issues there, at least early on, was the question of whether the civil courts had subject matter jurisdiction to entertain those cases. But that's more likely for Thursday as opposed to tonight, for you to at least start to think about those cases that we've got there. Well, let's talk a little bit about Sanguinetti and Nantucket construction, because there's a bunch of equitable issues here that we have to have a good handle on, not just for the exam, but so that we can be able to use these when it comes time to practice, because you will at times have to start to think about the use of constructive trust and resulting trust and the like. I think the most common example I've seen over the years, and it happens all the time, and probably some of you have some experience with it, is as the parent ages or someone you know ages, what oftentimes they tend to do is they want to make sure that their bills can be paid and they can access their money, but they don't really tend to go with the power of attorney or things like that. Sometimes they do. But the easiest way and most common way is they'll put someone's name on a bank account, and it will have an awful lot of money in it. And if it's a joint account, when the first person dies, the other, at least on paper, is the sole owner of those funds, and they may forget that mom said that you're supposed to share that with your three brothers, or whatever is supposed to happen with it. And so we have to look at some other types of solutions potentially to being able to recapture those proceeds. And it's not just bank accounts, but that's the most common. The same type of thing, some people will think, well, I could avoid probate if I just put Johnny's name on the deed and he'll take care of everyone later on. Well, Johnny has a short memory when dad and mom goes, and all of a sudden the house and what they thought was likely to be shared by multiple parties is now, at least allegedly, owned by one. So you're going to have to settle somehow this problem, and it may not be by way of a settlement. It may have to be by way of some form of litigation. So let's take a look at the Sanguinetti case, because there's a bunch of things going on there that you should be comfortable discussing and explaining. It says it's a declaratory judgment action, and we looked at those before. A declaratory judgment is where the court is going to determine the rights and obligations of the parties to a real or threatened controversy. It can't be imaginary. But remember, when we looked at those in the picketing cases and the like, that the window on a declaratory judgment is somewhat narrow. It has to be when the controversy is sufficiently ripe that it makes sense, but at the same point that there is in fact a controversy in essence, but it has to be before other actions are already pending, because then it would be more appropriate to simply resolve those actions. And so the declaratory judgment, in my experience, is usually used as a count of a multiple count complaint. Sometimes you see it just brought by itself. I think it's most effective as a count of a multiple count complaint. But this is, at least in part, a declaratory judgment action. And then we've got some other things going on here that you should be able to define and explain. It talks a little bit about fraudulent concealment, and you should understand what that means. And then it talked a little more about laches. And so, so what's fraudulent concealment, first of all? What does that mean? Fraudulent concealment. This beautiful summer day, no one wants to get out a little early. We'll sit here quietly and look at each other for the next
person that they had an action had they known all of the facts, but they didn't at this point, so he concealed the action, and therefore it didn't, the statute of limitations didn't run.
Say what?
The statute of limitations didn't start running.
Okay, so if we were going to try and define that in general, not just in this case, because but you're right, in this case, what they were looking at, what would you say, how would you say fraudulent concealment works, or under what circumstances would it work? If we were to look for some broader application. It's not a terribly obscure concept for looking at the name. Fraudulent concealment, in essence, means what?
Well, just going off of what Geneva said, in general, it's just would be something that facts that one person hides that if exposed, the other party would, knowing those facts, would know that they have a lawsuit.
So, okay, so when a defendant wrongfully conceals his illegal actions from someone. Go ahead, Karen.
When one party makes a promise to perform with no intention of doing the performance.
I don't think that's this one though, right? I think these two are closer, because that almost sounds like some type of promissory or fraudulent estoppel or something. Because what he did here is he concealed his what appears to be illegal actions from the plaintiffs, so that the plaintiffs really weren't aware that they had a cause of action. He fraudulently concealed his activities from them to the point where they really, that if the facts had been made known to them, they may have pursued their claim earlier. Because that's what's kind of odd about what the situation we've got here, right? Is that if you know earlier, then you should be pursuing your remedy. And in the event you do not, then you're either going to start to bump up against laches or statute of limitations problems, right? And laches is an unreasonable delay in asserting your rights that causes prejudice to the other side. And that may still be an issue before we're done here. But when we talk about statute of limitations, we always get into that issue about, well, when does it begin? When does it begin to start to run? And a lot of times you guys say, well, when you knew or should have known that you had a cause of action, and that's not a bad starting point necessarily. But how long did this go on for? It went on for a long, long time, right? And the problem at some point is you do start to think, well, if there was a cause of action, this makes it very, very difficult to defend. And I'm going to try and defend who may be the indefensible, and that's Roy here. Well, would you all do what Roy did? I mean, because Roy seemed to have his hands in just about everything, right? Even the key to the registry office where he could come and go at various times. But I've always thought, well, he's just a small town lawyer who knows everyone, and sort of he's the guy you go to in town if you want to get things done. Is that such a bad thing? Or do you want to be Roy or not Roy? You want to be the go-to guy in town or the go-to woman in town? No? Why not? What's the matter with that? Is he the fixer? It's illegal, or is he just
looking for trouble, I think, all the time.
Why do you say that? Because every town has one, right?
Yeah, they do. And it gets a little easier to do a little more, and the next thing you know, you're over your head, you never saw it coming, and somebody gets smacked, everything comes down around you.
But aren't there ways to be that, and we'll just say guy for generic purposes, that guy, and not cross the line? Right? I mean, because it's clear the problem here is he's got his hands in everything. Everything. And if you're going to guard your reputation and your back from being exposed to liability, you should have been a little more careful. But when I said defend the indefensible, I mean, the suit isn't filed until after he's dead. Right? And he might have had explanations for a lot of what took place here. it is a little convenient that the suit only comes when he no longer can speak out and explain what the circumstances are. No? Or, no, Professor Cooley, you're defending the indefensible. He's dirty. He's not just in bed with his clients, he's stealing his clients' property. And either they're clients or business partners, but I don't see how they're both. And I don't see how you can protect their interest if, in part, your interest is adverse to theirs. Is that what it is, or is, now he's a good guy, he's just trying to help everyone out? Melanie, you don't look like he's trying to help everyone out.
No, I think he's kind of sleazy.
Why do you say that? Because he ends up with
Because
his
he
name
did.
on their property? I mean, is that it?
Just about everything that he's done in this case, I mean, I'm taking ethics now, but, I mean, just about everything in this case is a violation of some rule or another. I mean, where do you draw that line? If I have to ask if something's okay by looking at rules, then I probably shouldn't be doing it.
Well, that's, what do you think of that? Is that a pretty good rule to run by? Because I'm not so sure it isn't. I mean,
I think today, you know, in the past, you could do stuff like this. I've known people like this. You've known people like this. And you know, everybody loved him, but then you often wonder, well, why is he driving so-and-so's Ford-digit license plate? How come he's driving so-and-so's Fleetwood? You know, I mean, they all seem to kind of attract all the goods. They never took risk. You know, they'd always take the good side of everything, you know? And you know, eventually, over the years, people started waking up to this stuff. It became easier to see what was going on. And next thing you know, a few people started going to jail, and we ended up with these ethics rules. And now it's really different. You know, they're threatening to expose you before you can do anything.
but could you be that small-town lawyer without crossing over the line or not? Go ahead.
Yes, I think you can, but I guess it goes back to all his intent. You know, your intent. We talk about that a lot in law school, is the intent. I mean, and it said warranted on the evidence that he was intentionally trying to defraud the company. I mean, alongside with everything else, the ethical violations that, I mean, we go back to that mens rea, that mentality of what he was doing. I mean, it wasn't that innocent guy trying to help everyone out a little bit over his head. I think he knew what he was doing and was trying to play, trying to play the fool in an aspect of that, and he took it to a further extent. And I feel as though that he wasn't the innocent guy, trying to help everyone out. That he did have some negative aspects, and his intent was bad.
Is that what you think? You think he's much more black-hearted or misdirected? Go ahead.
But I think what you asked us is, can you be an attorney in a small town and do it lawfully? Because that's what, I mean, he should have known. the
Well, but
things
that may be overly simplified question of mine. Can you practice law in a small town, be the go-to guy, and not cross over the line like this?
Absolutely,
You think?
absolutely.
I'm seeing some dubious proposition over there from John. John, no?
Yeah, if the town is small enough, and if you're involved in too many things, you really have to limit what you're involved in.
But as long as you're, just if you disclose and you're honest, then of course you can. I mean, you can't promise everything to every person, but it's like saying, can a politician be honest?
We might end
Or
up
can it-
disclosing one information from one person to another.
Right.
But you know everyone's secrets at some point, right? You know an awful lot. You know enough secrets that
Well, then.
you've got a lot of capital in play here.
Yeah, he was playing everyone's card. He knew the cards to play, and he was playing them at the appropriate time. And I feel as though, again, going back to my original argument, that he was intentionally trying to, defraud people around him. If not to direct, at least a little bit, he knew he had to have that knowledge that he was doing some negative.
He had to know.
He had to.
Right. But of course you have to recuse yourself. Sometimes you can't defend both the defendant and the plaintiff. But you certainly can say, you can try to do as much and give them good referrals. I think that you can do it and be honest.
Well, when you say good referral, is that all that's required? If I get one of these lines here, it says, with this NCC, this is on page 233, Rounsel prevailed upon a friend won folks to grant a loan of $30,000 to NCC. So he went out, found a friend at the Capitol. Rounsel and folks left the terms of the loan to Sanguinetti. So it was his requirement then to figure out what the terms would be. And it says, to Sanguinetti, who acted as attorney for all of the parties. All of the parties.
Obviously, he shouldn't have been the attorney for all of the parties.
But so is that all I gotta do? Is I'm gonna say, no, Fred will represent you as the buyer. I'll take care of it. I'll take care of all the paperwork. My friend Fred, I'll just leave that part off. But Fred will represent your interests.
Oh, hopefully.
No, is that all we have to do?
Again, that's good.
So I just have to have enough of a circle that I can spread it around, and they'll spread it around when they need independent counsel.
If you conflict somebody out, you can't give them any advice, I would say, if there's a conflict.
Well, I can't even, I can't answer your question, well, who should I go see, Mike?
I don't think so.
I can't even give you a
I
recommendation.
think you can give a referral, but I don't think that you can be and remain involved.
Oh, you mean I can't represent the rest of this anymore?
Well, no, because you still have information about all the different.
Well, then I won't give you anything, I'll just keep the pot I was gonna keep. And is this the way you think it works? I mean, because, listen, I do not practice law in a small town. I have practiced law enough in the small town when I'm out of the small town to recognize that there's always someone in the community who represents the planning board, represents this, his friend, they play golf on the weekends, and this someone's gonna get it done, and there's a Sanguinetti in most towns, and if you call someone in that town and say, listen, I got something I need before the planning board, who should I talk to? And you're gonna say, well, I would go see this person. I was down in Plymouth on July 3rd, and it's like one of the biggest holidays ever in Plymouth, and 4th of July and the 3rd. And this homeowner, I know what he was trying to show me, it was 9:30 at night on July 3rd, and he wanted to show me that he could call the head of the planning board on July 3rd and get whatever information that we needed at that point, or that he needed. I didn't need it. He was just simply trying to impress me with how something got done. I don't think that's that uncommon. So, I mean, I worry. I don't think it's right, but I would just want to make sure that how you're not going to do this, because this one is, in hindsight, this just looks terrible, right? I mean, this really isn't the defendant, and it does look like, I think he did break into the registry of deeds too. Didn't break in because he had the key, I guess, but he went and phonied the documents up, didn't he? It says the number 8536 written on the blue backer on the trust instrument was in the handwriting of Sanguinetti. The judge found the document number was placed on the backer by Sanguinetti in an attempt to establish a false registration of the declaration of trust. Because of the informal operation of the local registry of deeds, he had free access to it even at hours on days when the registry was closed. He had a key to the registry and the combination to the safe. It really is. I mean, honest, right? It is amazing when you look at this.
How long ago was this?
60s.
Yeah.
So there's been some.
I don't think that you can do that now. Not even in New Hampshire.
And it wasn't even in New Hampshire. No.
I know.
Which, by the way, I have found things are a little less formal.
What, in New Hampshire?
Yes. I like dealing with our town hall here as well, but I do like dealing with the town hall. Seem people very pleasant and agreeable, and my guess is if one were to practice law on a regular basis up there, that there are ways to get things done informally that probably work out a lot better than formally, just because I think people are pleasant and nice to one another. Unfortunately, unfortunately, I think nicer than around here sometimes we are. But this guy, you guys are all comfortable with that he's just so far over the line. They have the plaintiff should clearly win. but you know what I worried a little bit about? Wasn't the plaintiff on notice when this whole issue about the bogs came up? And he said, that's my land now, you've lost it. And they do nothing? Even assuming he's your lawyer, and you trust him, which I think obviously that's a pretty good place for them to start. At some point, you're on notice that something's wrong here, aren't you? But you don't have to do anything to protect your rights? Does that part bother you? Because that to me starts to give us some cause for concern about how innocent the plaintiff is and how unaware the plaintiff was here. I mean, isn't that enough that would put a normal person on notice to say, okay, I'm getting screwed here, or I might be getting screwed here, I need to go see a lawyer. And this guy does nothing? Does that not worry you? I mean, does that, because I assume, I didn't ask yet, I assume as horrible as Mr. Sanguinetti is to all of you, you would still defend him. Or is there someone here that when the widow comes to you, you can say, no, I can't defend this? He's got the assets, so he must have some cash to pay too, right? So you will defend him, won't you? Or you look at this and say, no, clearly there is no defense for him. Or is there?
Well, you have to find a defense.
Well, tell me why it shouldn't. Go ahead.
Didn't he sent a letter, I think, when his son when they told his son not to hunt on the bog.
Right.
Not only did he say, this property's mine now, I think he also sent a letter to them.
I think that's right as well.
Representation.
So, that isn't enough to put you on notice that you should be reasonably diligent about pursuing your rights at this point?
Likely did, but they were probably so intimidated by this man's position and power.
Well, but isn't that convenient to say after he's dead too? I'm by nature cynical. That's what we lawyers are, right? Cara wrote in a paper the other day, my mother and father are lawyers, so they don't trust anyone. They didn't say, maybe it wasn't quite that bad, but that's the way I took it, first of all. Unless it can be proven that there is no other possibility, they don't believe anything. And I had to explain, I had to explain to her from the paper, by the way, she's in college. Well, it is an oversimplification, but I do think by our nature, our training makes us cynical and skeptical and tells us to question everything, right? And
I think it's that those are the people who are attracted to law as well. Even before your training, there's something why you want to be an attorney, because you have that perception of different sides of stories.
So it's not just the training, we come into it a little jaundiced and we leave even more so. So do you think her characterization was more accurate than less accurate then? I mean,
Your daughter's characterization of you? And you
of you. It doesn't just apply to those two lawyers. My guess is her characterization would apply to all lawyers. That we tend, and it wasn't put in trust. It was that they don't believe anything unless it can be proven that there, in essence, was no other alternative. I had to reshape it for her. So to sort of understand, there's more than a kernel of truth there. But it's not quite that we don't believe anything unless it can be proven beyond any other doubt.
I would agree that lawyers are far more skeptical than most other professions. I would agree with that kernel of truth for sure.
And
do we trust less? Because I'm adding that, because
sure.
that was the implication. So we do trust less.
But I would not.
Is that from training, or you're saying we brought some of that to the table when we started?
I think part of it's innate, but as a parent, I think that was a compliment think that she
Didn't
was.
read like a compliment when I saw it writing on the paper. I said,
Well, I
well,
think you should perceive it and tell her that as well, that it's to your analytical ability to look at all sides.
well, we had a discussion about it, because I don't want her to think I don't trust anyone. But that's the way, go ahead.
I would look at it the opposite and say that we have the ability to believe both sides.
Right.
That whichever one we want to pick, we can force
Right.
ourselves to
Turn
be
a-
wholeheartedly into that side.
Turn a blind eye.
And yeah, and feel like that side's correct and that we have the ability to.
Do you
speak
think that's
that.
true, or is that just another lawyer's argument? Because we don't have to believe, we don't have to believe any side to argue for it, right?
Right.
No, I
Right.
don't mean believe for the side. I mean, like, believe in a side. You know what I mean? That, like, we might not
But
think
you
the right
believe in
way-
the argument, don't you? You don't believe in the side.
Right, in the argument that
argue
you're
both
saying.
ways.
Yeah, to argue both.
No, you know, but hold on, there's a difference here, right? I'll represent someone, but I have my doubts, right? You have your doubts. So I don't,
Not in front of the
listen,
court, you
listen, I've been around enough, Kara's right. I don't believe everything any client says, because,
What are you pointing at?
well, I'm saying, I don't believe everything any client says. That may sound horribly cynical, but I think it's something you need to think about as well. So I'm not even sure on the sides I believe in. The sides I argue for, I totally believe, because there's always, people leave some of the stuff out, and all of a sudden you get. I do think we are taught to question everything, and it's not a bad thing, especially as a lawyer. Go ahead.
No, I was just gonna say, I definitely do think we're cynical, and I have to agree with Karen in regards to, I think we are drawn to this profession by that nature as well. Even before I started school here, when I was, at my job, I would ask somebody something, and then I heard someone else say jokingly, "Oh, don't even bother answering. She's gonna just go Google it anyway to make sure you're right." Which is partially true. I feel like I always need proof to anything that people say, even in general.
Yep.
So I do think we are skeptical. I don't know if that's bad or good. I haven't decided on that yet.
Go ahead.
I think another part of it isn't just the overall trust, but the idea that, we're trained to think in the most minute of details. And when you get somebody that's very much a generalist, which is most people compared to us, they make a comment and all of a sudden 5 issues pop up in your head. And when you start bringing these things up, of course, then they get annoyed. So, what you meant by that was this, and I know you really didn't mean that. Next thing you know, it's become a whole big thing, and all they said was one sentence. But, that's what ends up happening. Then they think you don't trust them, or you don't believe them. All you're trying to do is get them to realize that it's not exactly what you think it is. There's more to it than that.
And no, I don't trust you. Well, but because that is that's the way people perceive it, but that isn't part what we're doing. I don't trust everything you have to say. That's part of my nature, it appears, and part of my training, that we question virtually everything. So let's focus back on our case. You can think about the other part of the little dilemma. So I'm questioning the plaintiffs, because I don't believe everything they say. I think the defendant put himself in far too many positions so that whether he's dirty or not, he looks dirty. And from a lawyer's standpoint, you can't place yourself in that position because you got to protect your backside for when things go bad. And here, there really is no protection for him because he's got his fingers in everything, and he can't possibly be protecting everyone's interest. But tell me why I'm wrong about the plaintiff. The plaintiff gets notice that the attorney is, at least in part, acting adverse to him. They really don't do much to protect their rights, and instead they wait till after he's dead and then bring this lawsuit to recover virtually all of the stuff that, at least at the time, when the argument over the box came about, my guess is we would have had significant contrary testimony from the lawyer and the defendant in the case. What about that? Does that bother you too, or it bothers me but not enough because I still can't get past what the defendant really did here?
I agree with you. I couldn't get past the one paragraph where he said he discounted it because he knew he was a sick man, suffered from
that right? If you remember Penoya versus Nefwitz, you read first year, the reason they went and got that lawyer to begin with is that lawyer was known as the one who could get things done and help them with the land. You know, you lie down with dogs, you get fleas. This is not uncommon that the likelihood is that we were working together as long as everything was good for us. And when it hit the fan, like rats, we all run our separate ways. I mean, I do worry a little bit about that. Let me ask you about the constructive trust and the way in which that works, because we've got a couple of important terms to have to understand here. Constructive trust, resulting trust, and then declaratory judgment we've looked at before. But this is the first time we've looked at a constructive trust. And it's not a trust in the formal sense as one would draft a trust document as in the expression wills and trust. This is done by operation of law over property. And it doesn't have to be real property, it can be personal property as well. And if you look at the definition, and this is on 236, a constructive trust is imposed in order to avoid the unjust enrichment of one party at the expense of another, where legal title to the property is obtained, A, by fraud, B, in violation of a fiduciary relationship, or where information confidentially given or acquired is used to the advantage of the recipient at the expense of the one who disclosed the information. So in order to impose a constructive trust, and that's what the court actually does. It imposes the constructive trust on the property if that's what's sought. You have to show that title to the property is obtained by fraud, or B, in violation of a fiduciary relationship, or C, where information confidentially given or acquired is used to the advantage of the recipient at the expense of the one who disclosed the information. If the property in question isn't, in fact, if Sanguinetti took the property in question improperly, which one or ones might it be in order to impose the constructive trust? Do you think he obtained it by fraud?
Mm-hmm.
Yeah.
Do you think he obtained it in violation of a fiduciary relationship?
Mm-hmm.
Do you think he took information that was given to him confidentially to his advantage at the expense of his client in this case? And any one of these is sufficient.
Yeah, or.
Any
No,
one,
and.
any one of these would be sufficient for the court to impose the constructive trust on the property. And see, what's important about the constructive trust as well, or the resulting trust, where the constructive trust will follow the property and the proceeds, is that you may then be able to recover the increase in value of the thing as well. It's one thing to say, well, the property was worth $10,000 at the time it was taken, I want $10,000. It's another thing to say the property, when it was taken from me, whatever, it doesn't matter what it's worth because it was taken improperly and I want a constructive trust imposed, and that property may now be worth $1 million or more, but you can have the trust imposed if in fact meets the requirements that we just outlined above. And if you look at the language here on 237, the court is in fact going to impose the constructive trust, and it'll follow the property itself. So it's not just going to be cut off, but here this action can be, since it's placed against the real estate, can go to Lucille as the new, I think she's the trustee at this point. Oh no, her, she holds the record title as his successor trustee, who has the property, and it's not then going to pass to his heirs or his the estate of trust, it's going to go back to the original, who should have been the true owner. They don't look at resulting trustee, and we're going to look at that in Sullivan versus Rooney. It's another important case with respect to imposition of equitable trust. It talks a little bit about, on 238, what fraudulent concealment will work. At least it explains that if there's been fraudulent concealment from one person who was entitled to bring an action, the period prior to the discovery of the cause of action is excluded from the limitation period. So in essence, for however long you can show fraudulent concealment existed, that period doesn't count against the statute of limitations period. So one way we attempt to overcome the statute of limitations, and you remember the statute of limitations is an affirmative defense, and it also is going to be for a set period of time. 3 years for tort actions in NAS, 4 years for consumer fraud, 6 years for contract actions, 20 years for contracts under seal. But that statute of limitations is the period in which the action should be brought. As an affirmative defense, the defendant must plead it in order to try and defeat the plaintiff's claim. Fraudulent concealment is a defense to the statute of limitations argument that the plaintiff would plead in order to argue that the statute of limitations should not be held to bar the action, in essence because the defendant has taken steps to conceal their illegal activities from the plaintiff, who otherwise would have been able to pursue that claim. Now, I just want to touch on the laches argument just briefly. They say, the Supreme Court, the appeals court says, that they agree that the laches argument doesn't bar recovery, even assuming that the defendants were aware of Sanguinetti's adverse interests as early as December of '68. And I'm going to read you the next language because maybe this is just the defendant's failure to really put this argument more fully forward. There appears to have been no acquiescence by the defendants in the wrongful acts of Sanguinetti. Geez, I don't know, maybe no acquiescence, and I'm not sure it's necessary for laches. That sounds more like an estoppel. No lack of diligence on their part in seeking a remedy. I don't really agree that there was no lack of diligence. And no positive showing that the time element involved in bringing suit operated to prejudice the plaintiffs. Well, the prejudice here really, it should be, is to the defendant, right? That the defendant, with his testimony, had he been alive, certainly would have been in a better position to try and refute some of the claims. Maybe it just wasn't advanced as solidly as it should have, but I would think that was deserving of more than a paragraph worth of explanation as to why laches shouldn't, at least in part, potentially bar some of the claims that the plaintiffs have asserted here. And so I'm not quite sure I agree with it. I'm not sure, I don't disagree with the decision itself, but I would have preferred that we get a lot more of a discussion with respect to the laches argument, because I don't think it's clear at all that the plaintiff didn't delay to some extent to their advantage and to the defendant's disadvantage, and I think that would have been at least worthy of further exploration. Let's take a look at Sullivan versus Rooney. Sullivan versus Rooney is another case where the court is asked to look at whether it should impose a constructive trust or a resulting trust, and it helps us define the difference here under mass law. So she's got nothing in writing whatsoever that says her name is supposed to be on this property, right? Nothing. Isn't there a statute of frauds? Right? What's the statute of frauds say?
Real estate must be in writing.
Agreement concerning real estate must be in writing. And she's got no writing, right? And in Massachusetts, we don't have palimony, right? Unmarried couples who live together do so at their own peril. No, right? But she's found a way around it. Hasn't she? No. She's got no writing. It doesn't appear she contributed financially to the down payment. Am I mistaken on that? She never paid any of the mortgage payments, correct? All the real estate taxes. So now she comes sideways to grab the house.
But the unjust enrichment portion of that, how they imposed the constructive trust, does that come in because he was getting the veterans financing? I mean, how is he unjustly enriched? That's what I couldn't grasp. That why the court imposed the constructive trust.
Well, what do you guys think the argument is on how is he unjustly enriched? Or how would he be unjustly enriched unless they impose the trust?
The whole benefit of her.
Of her or the house?
Well, he paid for the house, but all of the other stuff, she paid for the furniture. She like cooked and cleaned and did everything inside the house and outside the house and everything like that, and gave up her job so that she could take care of the house and stuff like that. So he was unjustly enriched in that sense.
Right?
The court here is saying that just because he promised her that the two of them would own the property and then he got the property alone, my understanding that's the only way that they are saying that he's unjust enriched, because she should have got the property together.
Well, I mean, that's the language here. It's on 162. That they do talk a little bit about the promises he made. Plaintiff brought this action to obtain title to the house as a tenant in common with the defendant. The judge found the defendant had promised to convey joint title at the time of the purchase. This is the judge's findings. He reiterated that promise on several occasions. That's the judge's finding. In that he admitted to having made these promises. Judge further found that in reliance on these promises, plaintiff was induced to stay in the relationship, to contribute her earnings and services, give up her home in Virginia, and that she did all of this to her detriment, giving up her position as a flight attendant. And then the judge ruled that the defendant would be unjustly enriched if we were allowed to keep sole title to the house. The judgment ordered the defendant to convey to the plaintiff a half interest to the house, and they took the case on the defendant's appeal.
So the court took a number of those factors and her contributions over the 14 years into consideration. That's how overall he was being unjustly enriched.
Well, I think the biggest, I think all of those things show her contribution, and it would be an unjust enrichment to allow him to take sole title to the house because of, as the judge saw it, her extensive contributions. Well, but this is like a divorce without ever having been married, no? Huh? Well, it is. They're obviously using the language of quasi-contract when we talk about unjust enrichment and detriment and all the rest. But there is no agreement, you know, I'll pay so much if you cook and clean and give up your job. But, and it does talk about quantum merit, fair value of her services. But that's not really going to fly either, because again, we have nothing that really sort of documents this. And the court makes reference, or the decision makes reference to this argument about statute of frauds. And then it says here, top of 163, the judge's unchallenged findings of fact demonstrate that there was a fiduciary relationship between the parties and that the defendant violated his fiduciary duty to the plaintiff. and that we saw in the last one, constructive trust. That's one of the things that's necessary. Do you not in a fiduciary relationship? 'Cause
I didn't like that.
Why not?
I
Are
find
you
that
not?
offensive.
Huh?
I find that offensive.
So you're not, are you folks not in a position of trust with those of you that you either are married to or share your homes with?
You are.
You are. You're in a fiduciary relationship with each other. Are you? You all agree to that?
I'm on the team.
Huh?
I'm
Trust but verify. So no, but are you? Are you? Or,
Yes.
and is it too much to say that? Are you in a fiduciary relationship with those who you date? Or is this more than that?
This is more than, but I think this is a bad, I think this is a bad decision. I mean, I don't agree with this decision. I think he was, you know, exactly as you just said, he was looking at this as a marriage. And
He was or she
the
was?
judge. The judge.
Oh, the judge was, okay.
The judge was looking at this as a marriage. I mean, the only basis that I can see is that they're enforcing an oral contract, which the statute of frauds should get rid of, because she should have had something in writing. I mean, especially when he talks about her unfair position because she was a waitress and he was in law school. They're almost looking at, it's like what we looked at for a prenup, that it has to be, you know, it's not fair if someone is in a lesser position and they're negotiating. You know, that's how he's taking this apart. And I think it's wrong. I mean, as his attorney, I would have been surprised to have lost this.
So she shouldn't get anything for her
I don't think she should have. I mean, I'm not happy about it. I'm not saying that, but I think that this is wrong. I do think I don't think it's a correct decision.
I agree.
Yeah.
Good.
Unfortunately, I disagree.
I disagree.
First time for everything,
Oh.
only because it was a 13 or 14-year relationship.
She never paid the mortgage.
Right,
She
but-
never paid the
Okay.
taxes.
Right, but that's because
Let her
she
finish, though.
but that's because she gave up her job so that she could do all of that. Because she had a job, and then to get the house, she gave up her job, and he had a better one and was attending school, so she had to stay home. And if she had kids, that's okay for people to be, you know, for one parent to stay home and take care of the kids, and you always take that into
Well, wait, that doesn't mention anyone taking care of any kids.
No, I'm just saying that, like, you know, their lifestyle's different. You can't compare it to, say, someone who wanted to have kids and someone who didn't. Like, the fact that she entertained his friends at their house, like, all that stuff is things that you need to take into consideration. That to them, that was important. That she would be home and be a stay-at-home wife.
Wait a minute, so who says that? Stay-at-home wife?
Well, fiance, they were engaged.
Because there is a difference in the standard. Go ahead.
No, that's what I'm saying. I feel as though they came to somehow a wrong legal conclusion because they simply felt bad for this woman. So they kind of formulated it. I mean, because to get to that legal conclusion was kind of difficult to get there, and that's what I think we're struggling with. Simultaneously, she did contribute some, and you do almost want, you know, I do feel as though she should get something, but how to get from A to B is where it's kind of gray in this case, and I feel as though she should have got something, but and how did she, you know, she didn't sign anything, you know, there was nothing documented.
Okay, well, what if they had been married then?
Different.
So
Then it would be
why
much
is that
different.
different?
Because that's a legally binding
But why is it?
document.
But why is it? I mean, her contribution would be the same whether she was his wife or his fiance.
But they're
Because
not.
there's a legal contract.
But it's
So
a legal
because I
and it's
take
a-
his name, I have a cohabitation agreement, so this will never happen to me.
See,
But-
so that's how you're backed up for that.
Well, you have it because there's a value in having a written agreement, and they've reduced this to what, you know, there's no.
I have it because in the
Take
last
out
20 years, I've probably had to do 15 petitions to partition because people move in together or buy houses together without being married, and somebody ultimately gets screwed.
Yeah, but where does it end?
So-
Like, if we're dating, you know, for 2
Oh,
years.
it's 14
you know,
years though,
what-
it's not.
Do you have a claim
5,
to?
7, what,
you know?
he wants to know what the number is, so he can
Yeah,
make sure he
what's
gets
the
out before
magic
that, or
number?
get your ass out
Yeah.
before
He
that.
lied to her.
No, I mean, there's
Huh?
a reason
He
there's
lied
people get
to
married.
her.
Who says he lied to her? She does.
Well, yeah, but the husband admitted it.
No, he's not her husband.
I mean, the
Fiance
fiance admitted
that.
that he told her that, and that's what he did, and that basically, in and of itself, he was kind of being fraudulent because he only wanted to put his name on it so that he could get a discount, which you're not supposed to do. And he did that.
But wait a minute though, that doesn't send up the little red flags in your head. Oh no, honey, I can't put your name on it. It's VA says just my name. I mean, oh okay, that everything's good still.
Well, yeah, because people want to be sneaky and they want wanted to save money and take the shortcut and everything
She
like that,
knew
which.
that they were doing it.
Right, she was in on it. I'm not saying it was just his fault that they tried to be sneaky with the VA, but just in general, I think that matters, that they were there for 14 years and they had an agreement and she gave up a lot of stuff.
But this is, as his point tried to make it, this really is trying to take the law and twist it to come to a favorable result for a sympathetic plaintiff, right? Because, I mean, we say in Massachusetts we don't have palimony, but this is pretty close to it, isn't it? I mean, this is pretty close to recognizing that we're going to be making distributions of the marital assets when there's been no marriage, and there's no writing to support any of it. I always worry a little bit about the language here that says, and he admitted this, because I don't know whether that's the judge's finding or he actually testified, yeah, I told her all those things and it was a lie. I'd really like to see the transcript, because I have a hard time believing that he actually got up and admitted, yes, I promised on many occasions that I would, but I didn't, as opposed to, I didn't say that, but she says, no, he said it, and he said it a lot, and the judge accepts her saying he said it. Go ahead.
But don't we have unjust enrichment in all other cases? It's the same thing. I
Do
mean,
we have?
Yeah, we have. I see it all the time at my job that they do unjust enrichment. Good services rendered.
Sure. Absolutely. I thought you meant in sort of the relationships
Oh,
situation.
no. I'm just saying, like, it's no different than, to say that there was no legal contract here. Well, there's never a legal contract.
Which, by the way, I mean, we haven't really talked about, but those are considered equitable remedies as well. We don't talk about, and the fact is, oftentimes, we will plead complaints where there are unjust, the argument is it's unjust enrichment because they never reduced it to writing, but someone made money and someone owes the other person money. This is done all the time. I had a huge case where they had an agreement to share an invention dispute, and they never reduced it to writing, and it was a huge invention. It was a cardiac catheter that was worth millions before they were done. But they didn't take the time between the two physicists to sit down and sketch out a piece of paper that said, okay, when we get all this together, we'll each split whatever comes our way. And it made the case very difficult. But again, you could still plead unjust enrichment and have the argument. And that's in part what they're doing here.
Isn't the court saying this was an oral contract more than getting into the whole, really? I mean, essentially, rather than saying this is akin to being married, they're saying this is an oral contract. I promise you to do this if you do these things.
But so you're enforcing an oral contract concerning real estate.
Well, that's the problem.
No,
Yeah.
that is the problem, right?
Yeah.
So are you all in a fiduciary relationship with those who you share your homes with? For a year or two?
I'm
Huh?
married.
Okay, so you are?
In a fiduciary relationship?
Yeah, is that because we're married?
Well, we're protected legally because.
No, but are you in a fiduciary relationship with your partner?
Yes.
Okay. Are those of you that, with the boyfriend-girlfriend situation, are you? Are you fiduciaries to each other? No? Your fiduciaries being position of trust? No? No? We're gonna.
I feel like I am. I mean,
Well, you have a paper that says it.
We've been together for 8 years. I mean, the trust isn't because I have a piece of paper that says that, whatever I put into your house, you're giving back if you throw me out. I mean.
Well, that happened to me. Now that I think of it, I'm just sitting there thinking, I was engaged and I lived with somebody for 5 years, and he just woke up and decided he didn't want to be engaged anymore. And we had I'm over it. We had a condo, and during the time that we lived together, we did like it was Boston Police Gala Home raffle. We put in $100, and we won $10,000, and we put all that money into doing the kitchen, which I painfully designed and did everything. I did all the work for that, and yeah, I didn't get anything out of it. I just walked away like.
Well, I'll tell you another story. And let me just make sure that this isn't going to change on the basis of gender either, by the way. this was more than a few years
That's what I
back.
was gonna say, what if you
Sitting in the,
dating a
let me give it to
woman?
you, let me give it to you, sitting in this classroom, student comes up when we're done this lesson and says, Professor Coyne, he's a guy, police officer, and he says, that case, you know, shakes his head, you know, the think lawyers are cynical, cops are right there with us. He says, that case, he said, that, they don't really do that, right? And it's a SJC case, we just read it, he said, you know, a few years back, he said that I was living with this woman. I just came out of another relationship, but I was living with her for a little over a year. She didn't make a down payment on the house, that she needed to do the kitchen over. She said, before I'm done, he said, you know, I put over $100,000 into that house. He said, and then about another year later, broke up and moved on. He said, and I went to a lawyer, and they said, no palimony, nothing, you're out of luck. He said, does this case say that I potentially had a claim for, and he was no BS, you know. And I'll tell you, for $100,000 in some form of either likely constructive trust or resulting trust for the money I put into that house, would it make a difference to you that the gender of the claimant there is a male?
No, it makes no difference. It's a gift. That would be a gift.
Oh, that's a gift? So, gender makes no difference. That's a gift.
Yes, because in this circumstance, there were conversations that they had, or that came out in trial that they had with each other. I don't know if it's true or not, but from this is that there was a conversation. They agreed mutually with each other that they were going to, that she was going to give up her job and give up all this stuff to her detriment for the house, versus him saying, "Oh, here, I'm shelling out money for you for nothing." He's not getting anything.
Nothing.
In
He
return.
gave the deposit. He
Right,
made
he
your
gave
own.
all money for
Can I ask-
nothing.
Well, I don't know about gay, because I would think.
Can I ask Genevieve a question?
Yeah.
Can I ask, wait, I have a question for you. You
Yeah,
work-
he was living in it.
But
He was
for-
living in the house,
you
just
were-
as she was living in the condo.
Correct.
You work in an attorney's office.
Yeah.
Do you do closings? Do you do?
I do not.
But you do, you're
So,
familiar,
yeah.
all right. I have a quote from the case. On the way to the registry of deeds for the passing of papers, he told her he was going to get 100% VA financing, that he would have to take title alone. Don't you think he knew this a long time before, and she probably knew it before that as well?
I think they agreed that they both wanted to.
No,
just-
she found out on the way to the registry.
Right.
You don't find out on the way to the registry, that's not true.
Well, but wait a minute though, Karen, that could work both ways, because that could be, he knew all along and then just said at the end, hey, by the way, you can't do it, it's on. By the way, you shouldn't trust me anymore.
I thought she knew prior to.
She knew her name wasn't going to.
Oh.
No, from this it's implied that she didn't know.
But I think that fact either can make, you want to use it to make her look bad. One could argue he knew that well in advance and was holding that because he didn't want to have a big fight and a lot of time to potentially fix it prior to. That one, I'm a little troubled by that
And
because
they
I can
did-
see that fact going either way.
And I heard she hated her job as an airline stewardess.
Right, but you
So-
do the things you don't like if you need the money.
But so wait a minute though. So did your former classmate have a claim for constructive trust for $100,000? Because just so you know, I mean, clearly it wouldn't even have been coaching. His expectation, he wasn't an internet millionaire. The expectation was he would live there, they would live together in this house.
But going back to your original, I think a judge would have more. I think the judge would have more sympathy. I hate to say it, but for the woman versus the guy, for the prior student.
So it is sexism, because he at least could show 100 lives.
I feel as though a little
real contribution.
Minutely that there would be, but then again you go back to the conjunction of her contributions and the assurances, and we don't know if we had that in the prior student's case. All those, did she give assurances that they would, is an equal scale as this case? It mimics it, but I feel as though it would be more of a difficult for the prior student versus this case.
See, I think it's more similar to hers. I don't think this one is even remotely similar. I think her situation is far more similar to this other guy, and I think she would have gotten it over him because she and her fiance were putting their money together for a kitchen that they were then living in versus him trying to move into his girlfriend's house and then just shell out money for her because she says she needs to do all this stuff.
Wait a minute. I told you, he gave her the down payment on the house.
Right,
What's
And
the
then,
circumstances?
I'm
What's
sorry,
the
what?
circumstances of him doing that? I mean, he could have just been give her the money. He could have been like, "Oh, babe, I need some money for the down."
Girl, I'll take it a mortgage. Yeah, it's tens of thousands of
I
dollars.
mean, like, what's the circumstances? You don't know.
Well, I can tell you, I do know a little more, at least in part, and this is where the paper trail got in trouble. That he had finished a divorce, but just recently, so that he had assets he needed to put somewhere, and he thought he was starting his life over with her, and
What's his name on the
Okay, what happened?
put them there instead.
Did he write her a check?
What was his name
Yeah,
on the
he had checks that he could show those actual contributions.
Wait, are you saying this
But
is,
isn't-
he is putting a down payment on his house with
He
her?
put a down payment on her house.
It's all in her name.
all
It's all in her name.
It's all in her name, and he needed to leave it in her name for
Yeah, then that's his
reasons.
fault.
Huh?
He lost.
The reason.
Yeah, the question is, did his wife know?
Exactly.
His wife knew about, his ex-wife likely knew about the cash. But I'll tell you, my recollection is there were a couple of reasons, but I'll give you one of them which was more than legitimate. My recollection is he was being sued at the time, not by the wife, but because of either, 1983 or some type of thing where he shouldn't have been named, but he was. And so you're not gonna go putting
So why would you go
property
buy a
in-
house?
Huh?
Why would you go buy a house? Why wouldn't you
He
go like?
didn't. He was put in her name for those reasons, for at least part of that reason. I mean,
That's
fraudulent. Well, that could,
I still think he should have gotten able to recover
So
something.
in that situation, did they have some sort of oral agreements like they did in this case?
I think, yes, I believe the oral agreement in essence was we would live together in this house and share.
Okay, then that's
Okay, then
right.
yes,
You made
then
it
it should
seem-
work out like it did here.
Yeah,
Well,
that
well,
goes
wait,
back to the
though.
it goes back to the assurances.
But
in
it
this case.
didn't work out. That, the understanding was, I mean, listen, no one gives you that type of money without the understanding that we're gonna share this.
Some people do.
That you should find them. So I'm not clear though that changing the gender hasn't completely changed your decision.
It has.
It shouldn't.
It shouldn't.
It doesn't
But it-
matter. I agree.
So, but you agree,
I think he has an argument.
but I didn't think you thought she had an argument.
Well, no, I don't like it, but based on.
Oh, okay.
Based on the findings of this court, we have precedent that he could have gone to the court and said, hey, look at this. I mean, if I was her attorney, I'd be happy.
Right, and he clearly, he wasn't aware of the case, and whoever, by the way, and this is the point for you guys to take from it too, whoever he went to see had no understanding of this case, because if you generally knew mass law, you would say, well, we don't have palimony in this state, you can't sue for, these sort of the quantum merit for the reasonable value of homemaker services. But then we've got a case that sort of stands everything on the ear, by saying, well, we can impose a constructive trust. And equity, the court does have a great deal of latitude there. And I know we've got a sympathetic plaintiff, but how long did you and your fiance live? 5 years?
Yeah, I was just gonna ask, what about common law marriage? Is that like?
We don't recognize common law marriages in Mass either. So, I mean, that's why there's a bunch of Mass law that, against this background, what?
It's contrary, all of the mass law is contrary to this case. So is this good law, considered good law?
There's
Or
another
not?
police officer asking the same question. No, the answer is yes. This is good law.
It is, it's still good law, just check.
So, but yeah, but based on this, he would have a case, but would it result in the
But-
same way?
Yes, based on this, he did have a case. The
So
problem
what's
was
the
his
cutoff?
statute of
That's-
limitations had a problem.
What's the cutoff?
Yes.
On time.
Well, that's what I'm wondering
Would've
too.
been six-
If
it would've been
I'm
6 years.
dating a woman who owns a house, and I don't, have one anymore, because I went through a divorce. And I'm dating a woman.
gone.
She's got a house, and she says, "Oh, move in with me," and this house is good.
And fix
I
it up.
put money
Fix
in
it
it.
up. Fix it
And
up.
it only lasts a year. But I've put in $25,000 because we.
And a lot of labor. You
And
have
a lot
to change
of
your
labor,
guests
and with the promise that we're getting married, or
Yeah.
whatever.
Yeah, what's the
I can
promise
they're saying you can, as I
I mean,
understand.
that's crazy.
A
You
year?
know, there's no common law marriage, even if it's less than the 5 years, but let's say it's more than 5 years. That's why, you know, the statute of frauds exists and there's no common law marriage in Mass. So you kind of have to know there's a reason for that, right? You know, that you don't have much of a claim, but apparently you do. I don't know.
So you're gonna put
I would
money into
say-
somebody else's house not thinking that you're ever gonna get anything back?
What if you think you get?
Sign up for habitation agreement, Fred.
Exactly.
I'm not saying, no, I'm not, it's not a me personally, I'm just using that myself as an example rather than somebody else. I mean, it seems crazy. If you go into it, you know that if you're not married, I think, you know, or have some kind of a written contract, you're not gonna.
You're out potentially.
But
I would think.
unjust enrichment, I mean, that's like saying you could never get unjust enrichment in all cases that you can get it then.
That's
Why
a
would you give?
contract. You gotta have some kind of a.
You don't, but you
don't.
don't. So you would let Fred sue for unjust enrichment for all the renovations he made to her house and offset it against the fair market value of the rent. Correct?
If the intentions were the same and their agreements were the same.
Well, see,
No, I mean, and this is the problem with the case. We've got a very sympathetic plaintiff, but so what if it's 2 years, 3 years, 5? Where are the numbers here? Because it cuts both ways. And so those of you that are living with someone
Where is
now,
it at?
can they put a constructive trust on that law degree you're gonna get? Because
It's the same
they've been
thing.
sacrificing, putting up with all your lousy moods and everything else.
What do
And
we do?
now,
Pass the bar, you know?
I'm sure they'd like to.
well, that was the deal, right? You would go to law school, you would do well, and we would both share in that degree and the fruits of that degree when the good times came.
Well, we had cases like that.
Huh?
We had cases like that in Citro, I think it was.
Adopted.
Yeah,
Yeah.
yeah.
Right? Okay, while we're here, I want you to put the definition, which is from the next case, on resulting trust, so the two of them are together. Resulting trust, this is from 789 of the Fortin decision. A resulting trust in real estate arises where one party furnishes the consideration to purchase the property, not intending a gift or advancement, yet title is taken in the name of another. See, I think he actually had a claim for both. This is Fortin, 789. Resulting trust in real estate arises where one party furnishes the consideration to purchase the property, not intending a gift or advancement, yet title is taken in the name of another. And then it goes on to say, a resulting trust must arise, if at all, at the time of the execution of the deed. This is the type of thing where we see a straw, what we refer to sometimes as a straw transaction. The property goes into the name of someone who is not the true owner of the property. And that's done for various reasons as well. But so that you need to know both constructive and resulting trust. One party furnishes the consideration to purchase it, but the property is taken in the name of another. Title is taken in the name of another.
Professor, this
Yep.
case has been cited everywhere, so that whoever lawyer your prior student got did not do his homework. And it's been citing at Kansas Supreme Court and Northern Florida Supreme Court. And there is a lot of articles who cite this case as well.
Seems like you're overly worried about this case.
No, that's right. I would do it.
You worked for her back then, I probably worked on that case.
Oh, really?
She was with the piano and Dodson.
And it's,
We both do. Let me take a seat. Oh, what's the question? Yeah, we both do.